What was voted in the House of Lords on Monday for the reasons I and Lord Vallance have noted in previous debates. To clarify the understanding of the House, the data accuracy principle requires personal data to be accurate and not misleading for the purpose for which it is being used. The safeguard should ensure that personal data shared by public authorities with digital verification services for the purposes of verifying a particular attribute appropriately confirm that specific attribute in question. Public authorities and digital verification service providers are legally required to comply with this principle at different stages of the digital verification process. Although it is very unlikely, as I said last week, that digital verification services will be used in the kind of cases raised by members of the opposition, this means that if an organisation requests verification of a person's sex at birth, the public authority must not share data which records gender more widely for the purpose of that check. Likewise, digital verification service providers must not rely on data which records gender more widely as part of the verification process in this scenario. This government recognises that there are instances where sex and gender data appear in the same field in public authority data sets. Existing legislation already requires personal data to be accurate for the purpose for which it is being used, and this means that personal data processed as part of digital verification checks must reflect the specific requirements of that check. I would like to assure the House that if the government were to identify an instance where a public authority was sharing gender data mislabelled as biological sex with digital verification services, we would respond appropriately. To reiterate, this government considers the issue of data accuracy of importance and accepts the Supreme Court ruling. This judgment and its effects must, of course, be worked through holistically, with sensitivity and in line with the law. The government is already undertaking extensive work on data standards and data accuracy, which will consider upcoming updated guidance from the Equalities Regulator. I do not think it would be appropriate to legislate in the way proposed without having taken these steps, particularly given the sensitive nature of this matter and the potential to impact people's privacy and their human rights. Finally, Madam Deputy Speaker, I would like to finish by noting the opinion of yourself that Lord's Amendments 49B, 52B and 52C engage the financial privilege of this House, which the Government does not believe it is appropriate for this House to waive. I am sure the other place will reflect on this carefully during their further consideration of these issues. I'm grateful to all those who have intervened, and I hope I haven't managed to cut off anybody before their prime. Thank you very much.